where I am incapable of receiving that one judgment with extreme, almost briskly, with extreme excitement, to the extent that one would be even enticed. And I have had several comments outside where we are, pointing to the possibility that actually now Uganda is excelling in the form of judicial effectiveness and efficiency. In my opinion, that would be hurried and hyperbolic in nature. Why? Because the end result of a judgment or a decision of court includes, among others, the execution of such orders of such court, the implementation of orders, whether substantive or even advisory. We are also now dealing with a country where one would ask oneself, was this judgment, what is this judgment? For example, the implementation of the decision of court, what is it waiting for? Because we are in a country led in a style that is not as normal as one would read from text to text. For example, it looks like a decision has not yet been taken from the innermost sanctums of decision making of state, to the extent that even a minister has no final decision available to him until the innermost kitchen cabinet sits and takes a decision in a direction that would be preferable for implementation purposes. Number two, you find that even courts now are not at liberty to divulge any going forward. Yet a decision was arrived at. The day the decision was arrived at, we received pieces of advice from several entities, even intergovernmental and multinational. Geneva, for example, the Human Rights Commissioner gave his own opinion. He said, yes, let now the country implement the orders of court that would have otherwise included, among others, a stealth transfer of a list of all of those that were affected by wrongful trials for purposes of freedoms. My professor here has also alluded to a very serious fact. That decision also is tainted with a likelihood of interpretation that fundamental human rights have got an expiry date. There are those that have suffered a decision, are serving sentences by a court, one that has been declared incompetent, illegal, very extremely partial, almost non-existent. So when a court issues a decision, it should be that kind of a decision that affects even the rights that are being violated by those that ultimately were wrongfully imprisoned on account of such makeshift courts. So to me, there is also that likelihood. We don't have an expiry date to fundamental rights, but that decision established one. So I think that should be revisited. And my professor, I associate myself with that reasoning. We must go along those lines. And also, then number two, it looks like there is some kind of enigma. It is not properly understood. For example, in this case now, the arrest of certain people, including Dr. Besigye. Since the arrest was never understood how it was conducted, it looks like even consequent and subsequent imprisonment is clearly never understood. Who conducted the arrest, even police cannot explain, even the army cannot explain. It looks like this was done by some Gestapo of some sort, some secret paramilitary thing that actually conducted the arrest. Now it looks like they are still waiting for such orders from the same, for purposes that we can now see a concrete direction that the Besigye case could take. Now, the case of Aaron Chiza, if a court is declared non-existent, how would one be held still for contempt of a non-existent court? So in my opinion, Uganda now, the goodwill is something that we would like to look at. Let the president not think, or government, that there is anybody available to defeat it on account of justice, where it has to be produced. The problem with our leadership is that it would like to establish a kind of leadership which has got an umbilical cord, which is single, reaching to a single decision maker, but having tentacles in all organs of government, irrespective of whether such organs should be within the purview of separation of powers as a doctrine. To the extent then that now it looks like there is an order that is being awaited, to the extent that we can have freedoms ensue. In Africa, when you look at several countries, the effectiveness of our judicial independence here in Uganda is not mentioned even among us, the first 7 countries. Younger countries, younger than Uganda, have featured in the first 7 countries where there is judicial effectiveness and efficiency. Namibia, we are almost 30 years older than Namibia. Mauritius, around 4 to 6 years older. South Africa, it is unclear, but all of those countries feature, and Uganda does not, because we benchmark the wrongest countries. We are benchmarking Egypt on how court martials are actually trying civilians, benchmarking Tunisia, that civilians are actually court-martialed for insulting the president. And in my opinion, these are areas and countries where you will find a multiplicity of trips done by our own leaders in Uganda for purposes of benchmarking wrongful legislations that have definitely led Uganda into wrongful judicial path. So, a decision given by a court, access to justice has been given by our constitution, a time not more than 48 hours. If you continue to incarcerate anybody, that courts have actually within their own interpretation discovered that they are wrongfully in any other prisons, why would you wait for anything other than freeing such persons? Geneva has insisted that we must respect treaty obligations. Uganda, incidentally, is a signatory to several treaties. We have a constitution that equally also respects the principle. Yes, and even when we are looking at the national objectives and directive principles of state policy, particularly because that is part of the constitution when you look at Article 8, capital A, because it makes it part of the constitution. The pacta sunt servanda principle applies with equal force. Now, when Uganda is a signatory to the African Charter, what are you doing in terms of access to justice, improper imprisonment of persons? Uganda also prides itself in being a member to the East African Community. What are you doing under Article 6D72? So Uganda cannot be a country that quickly takes importance in signing statutory signing instruments, constitutive instruments establishing rights without respecting any. In my opinion, I think this is a governance issue. This is an issue where the government of the Republic of Uganda has to answer, and where it fails to, then we know why it does.
What does this mean as we draw closer to the political temperature come September, October, when nominations are happening, especially that NUP supporters were arrested around this season of politics? Dr. Kizza Besigye has been pivotal as an opposition member. What does this mean for the politics of the country?
For me, it is good that we are beginning to see the failure of implementation of a decision of court. It is this court that I do not want, in my opinion, to exaggerate whose importance, because I'm expecting that it has a decision to give early February next year.
Honorable,
now, until that decision is also given, I am not in a hurry to think that this is an independent
The same court has seen presidential petitions, and some of them haven't been, the recommendations haven't been implemented.
Yes.
Do you still have hope?
And besides, for me, I am looking at a decision where this court emerges as independent as practicable, to the extent that it can declare a nullity, an election where evidence has been given satisfactorily that an election has not been conducted in accordance to terms contemplated in the law. We haven't seen it in Uganda. We are not only waiting for it by way of axiomatic faith, but we feel there has been occasions where it should have been given, but has never. Okay. That is what I am looking forward to, established by this very court. And until that is done, for me, I am not available to celebrate, because you can imagine even a decision of such a court has not been implemented. So I am waiting for February next year in order for me to give a celebration that this Supreme Court is really a very serious thing, to give my regard.